Okay, let's unpack this. We are diving into what might be the single biggest regulatory signal for the future of AI in the United States. We're talking about this high-stakes clash between the federal government and state regulators, all kicked off by a massive new executive order, the EO, that just dropped on December 11th, 2025.
And for anyone holding assets across the AI ecosystem, this isn't just some political footnote. This is a definitive, I'd even say aggressive, signal from the administration.
Signal of what exactly?
That they're pursuing a deregulatory innovation-first path. And it fundamentally shifts how investors have to price risk and liability across the whole AI supply chain.
The whole supply chain.
I mean, from the hyperscalers and the big model providers, all the way down to the companies actually using this stuff.
Right. Risk just got completely restructured.
Yeah.
So let's start with a snapshot. What did this EO actually say?
Well, on December 11th, President Trump issued the order. It's called Ensuring a National Policy Framework for Artificial Intelligence.
And the goal?
The goal is stated right up front: to create a minimally burdensome national policy framework, basically to aggressively push back on what they're calling onerous and excessive state AI laws.
The ones they think are strangling innovation?
Exactly. The ones they think are hurting competitiveness.
What's really interesting here is the how. An executive order can't just wave a wand and make state laws disappear, right?
It absolutely can't. That takes Congress or a court. So the administration is using every tool it has short of that. They're applying intense administrative and financial pressure.
Okay, so they're turning federal agencies into weapons against state regulators.
That's a good way to put it. And the strategy has three main pillars, three directed actions.
Let's get into those, because understanding the pressure points is, I think, key to understanding the risk.
Okay, first, they're setting up a specialized AI litigation task force right inside the Department of Justice.
To do what?
Its job is to challenge state AI laws in federal court. It's a proactive legal offense.
Okay, so that's pillar one, legal challenges. What's two?
Two is money. They're directing federal agencies to use funding as leverage. Think of that huge $42 billion BEAD broadband fund.
Wait, so states with AI laws, the administration doesn't, could lose out on broadband money?
They could risk losing access to crucial non-deployment grants, yeah.
Wow. Okay, and the third pillar?
The third is directing agencies like the FTC, the FCC, and Commerce to set their own federal standards or issue policy statements that could, down the line, be used to argue for preemption.
So they're laying the legal groundwork for future fights.
Precisely.
This sets the stage for a massive federalism showdown. But let's pull back for a second. Why now? Why did the federal government feel the need to use this kind of sledgehammer approach?
The main driver is a total regulatory vacuum at the federal level.
Right.
The U.S. has completely failed to pass any kind of comprehensive federal AI policy. So with that void, the states just stepped in. You saw California, New York, Colorado. They all started adopting their own rules.
And that's what the administration and the U.S. Chamber of Commerce are calling a patchwork of 50 different regulatory regimes. What does that fragmentation actually look like for a company?
It's enormously complex. I mean, imagine you're a high-growth startup in Texas. You're building a model for the whole world.
Okay.
Suddenly you have to hire a legal team just for New York City's Local Law 144,
yes,
which is about bias audits, and another team for California's SB 53, which is about frontier model safety.
Different definitions, different rules, different penalties.
Exactly. And the argument is that this kind of compliance becomes so expensive it hurts innovation, especially for the smaller players who can't afford it.
It's like a domestic trade barrier. But this EO didn't just appear out of thin air. This was the result of other things failing, right?
That's the critical context, yeah. This EO is basically Plan B. It puts their policy goals into action after they failed to get them through Congress.
Right.
Back in July 2025, they released their AI Action Plan, which warned about this state fragmentation. But more importantly, Congress tried twice last year to pass bills with similar preemption language, and both failed.
And there was that one Senate vote, wasn't there?
A landslide, 99-1 against a broad AI moratorium.
99-1. That shows you just how deep the resistance in Congress is to this kind of federal intervention.
It does, which is why the executive branch is pivoting to these administrative and financial levers. They couldn't do it legislatively, so they're doing it administratively.
And the core argument they're using to justify this is, well, it's fascinating. It's about truthful outputs.
Yes.
Are they basically saying that state laws are forcing AI models to lie?
In a way, yes. The administration's argument, and they've specifically called out Colorado's law banning algorithmic discrimination, is that these rules can force a model to change its truthful output. They argue that to get a uniform impact across different groups, you might have to force a model that accurately reflects the data to produce a different false result. They see it as a kind of ideological constraint on the model.
Of course, the states and civil liberties groups pushed back on that immediately.
Oh, instantly. California Governor Gavin Newsom called the EO deeply misguided and an unconstitutional overreach.
Their argument being that it's the state's job to protect consumers, to make sure AI is safe, trustworthy, and non-discriminatory.
Right. They see this as putting corporate profits ahead of civil rights. And groups like the ACLU are raising constitutional questions about the whole funding threat.
You can't just withhold unrelated money for a policy fight.
They argue it's coercive and unconstitutional based on Supreme Court precedent.
Okay, let's shift gears. Let's talk about you, the investor. This is a loud political signal, but what's the legal reality on the ground today? Does this EO just erase all those state rules?
Absolutely not. And this is probably the single most important thing to understand right now. An executive order is not federal law. It can't by itself invalidate a state statute. Only Congress or a court can do that. So all those regulations in California, Colorado, New York, they're still in full effect today.
So for now, companies have to keep complying while also getting ready for this wave of federal litigation.
Exactly. It's an incredibly disruptive ambiguity.
So the game plan is just, the federal government is going to start picking fights. Let's look at the 90-day action items. Starting with the DOJ, what's their main weapon?
The DOJ task force's weapon of choice is going to be the Dormant Commerce Clause.
Okay, for those of us who don't deal with constitutional law every day, can you break that down for us?
Sure. So the Commerce Clause gives Congress the power to regulate interstate commerce. The dormant part means that even when Congress hasn't acted, states still can't pass laws that put an excessive burden on that commerce.
So the DOJ will argue that trying to comply with 50 different state AI laws is an unconstitutional burden on a national company.
That's the argument, that it cripples national commerce.
And do we know which state laws they're targeting first?
Yeah, they've been pretty explicit. They're going after laws focused on transparency and anti-bias mandates. So that's California's SB 53 and New York City's Local Law 144.
Okay.
But the one that was singled out by name as probably the most excessive is the Colorado AI Act.
So Colorado is likely target number one.
It's widely expected to be, yes.
Okay, now for the second weapon, the FTC. The AJO directs them to do something very specific with the Federal Trade Commission Act.
Yes, within 90 days, the FTC is supposed to issue a policy statement classifying state-mandated bias mitigation.
The act of changing a model's output?
As a per se deceptive trade practice.
Per se deceptive. What does that mean in practice?
It's a game changer if they succeed. A per se violation means the action itself is automatically considered illegal. It doesn't matter what the intent was.
So it would become federally illegal to comply with certain state anti-bias laws?
That's the goal. It would create what's called conflict preemption, where a state law has to fall because it directly conflicts with a federal agency standard. A very clever tactical move.
Because it bypasses Congress entirely. And finally, the financial hammer, the funding pressure.
This is the most blunt instrument of the three. The Commerce Department has to issue a notice saying states with onerous AI laws will be ineligible for non-deployment funds from that $42 billion BEAD program.
That is a huge pot of money.
It is. The administration is betting that financial necessity will force states to align with their framework. It's an old tactic.
So on one hand, this sounds like a dream for large AI developers, less friction, fewer rules. But does this deregulation eliminate their liability risk entirely?
No, absolutely not. And this is where investors need to be really sophisticated.
Okay.
The EO targets statutory risk, the risk from laws and compliance costs. It leaves the rapidly growing threat of litigation and tort risk completely untouched.
And that risk is actually expanding, right? Based on recent court rulings.
It is. You look at a case like Garcia v. Character Technologies. That case signaled a massive shift.
How so?
The court treated a large language model, an LLM, as a product, not just an information service.
And if it's a product.
It opens the door to design defect and product liability claims. You can sue if the model produces a harmful outcome because of a flaw in its design.
So that Garcia ruling could pull in the cloud providers too.
It already has. The ruling allowed claims against the component providers, like the cloud companies offering GPUs. So yes, cloud providers are now much deeper in the liability net than they were before.
That's a huge shift. And what about IP? Intellectual property is another massive liability area. The IO touches on that too.
It does. The administration says it wants copyrights to be respected, but the strategy is really to push for a broad definition of fair use for AI training data.
So the DOJ would officially support the AI companies in those big copyright lawsuits.
That's the signal, yes.
And if they win, that could wipe out billions in potential liability for models trained on scraped data.
It would be a massive immediate win for them. But the market isn't really waiting for that. Licensing clean data sets is becoming the safer path for everyone, just to de-risk future lawsuits, no matter how fair use shakes out.
Okay, before we get to our trade idea, we have to talk about the carve-outs. The administration intentionally told Congress what not to preempt.
Right. This is a huge tell.
That's on that list?
The recommendation specifically says not to preempt state laws about child safety, state government AI procurement, and this is the critical one for our thesis, AI compute and data center infrastructure.
So they're protecting compute infrastructure from this fight.
They're actively promoting it. They see U.S. compute dominance as a national priority that shouldn't be touched by state-level fights.
Okay, that compute carve-out is a massive signal. It tells us where the regulatory risk is lowest. Let's pivot to our not financial advice segment and talk about the market implications.
The whole policy trajectory is pretty clear. It favors large-scale AI developers, and it protects computational infrastructure. That explicit carve-out for compute is, well, it's about as unambiguous a signal as you can get.
So we exploit that signal. We exploit that federally protected status. Here's the pitch. We're calling it the regulatory shelter arbitrage trade.
Okay, the action is to go long a basket of companies that are all about advanced AI data center hardware and infrastructure.
So not the model makers themselves.
No.
Right.
Like specialized chip makers, power grid modernization firms, utility companies that are focused on expanding data center capacity, the picks and shovels.
And why is this trade so plausible right now, given all the legal chaos we just talked about?
The plausibility is entirely in that regulatory shelter. The ETO creates a clear, favorable regulatory floor just for this one segment.
Right.
So while the model developers are stuck in court in California and New York fighting over bias, these infrastructure players are shielded. They don't have the dormant commerce clause risk. They don't have the product liability risk.
They're the protected backbone. So it's a bet on the growth of AI, but without the specific regulatory headaches of the models themselves.
Exactly. It makes them a comparatively lower risk bet on secular AI growth. They get all the favorable policy wins, but they're carved out from the state level interference.
That's the call. Okay, let's bring this deep dive home. What's the core tension investors need to internalize for the next year?
I think the core tension is this. You have aggressive federal deregulation pressure pushing for innovation at all costs. And that's clashing directly with the reality of state compliance and this rising court-driven threat of tort liability. The real fight isn't Congress anymore. It's in the courts over the Commerce Clause and federal funding.
And as we're all navigating this, what's the one final thought about liability people should keep in mind?
Just remember that no matter what happens with these state-specific AI laws, the big federal anti-discrimination laws are still there.
Like Title VII and the ADA.
Exactly. Title VII of the Civil Rights Act and the Americans with Disabilities Act. Those laws focus on discriminatory outcomes. And that fundamental liability risk is completely untouched by this executive order.
So winning the fight on state preemption doesn't mean you're free from liability.
Not at all.
Yeah.
A crucial distinction.
Well, this information is for informational purposes only and is not financial advice. Thank you for joining us on this deep dive into the shifting sands of AI governance. We hope this analysis helps you internalize these really complex factors as you evaluate the sector.